right, I know it's been a pretty long week for you. This will be the last that you have to hear from the lawyers, then you get to do some talking. I want to start with sort of the who, what, when, where, why, how. Since this is rebuttal, it's my chance to rebut their argument. I'm just directing you. That's not a combination to my school locker. That's the jury instructions that I think you need to take a look at. 21, 37, and 38. That's murder in the second degree, abuse of a corpse, theft in the second degree. These are the jury instructions. There's no 8th grade essay, who, what, when, where, why, and how. We spoke about this in jury selection. We have a checklist that we have to prove. It has the elements of the crimes. That's what we have to do. Now, obviously, it does involve some of it, right? Who? The defendant, Ivan Samuel Bremer, right? What? The 3 charges. When? On or about February 13th. Where? Here in Iowa, at least some portion of it. That's the territorial jurisdiction instruction that you got. I'm not sure if I've got that listed. I feel like it might be 19. And I'm right, 19, right? If an offense is committed wholly or in part in Iowa, then we have jurisdiction. So that's the where, right? Why? We don't always get to know the why. We can certainly guess, right? But that's not something we have to prove. And we're not in the guessing games here, right? How? Assaulted her, compressed her neck, hit her body, knew where she was, misdirected the police, took her stuff. I mean, that's where we're at. So that's we don't have any essays that we have to fill out, anything along those lines. Follow the checklist, follow the law. Another instruction I want you to take a look at is malice. When Mr. Munger was talking about it, he forgot sort of kind of an important couple of words there. He said, you have to show actual hatred, evil. Then he moved on to talk about what evidence do you have of actual hatred or evil. Sort of missed the third portion of that instruction that says evil or an unlawful purpose. There's no suggestions here, there's no evidence here that Mr. Bremer hated Eileen Gow. Don't know there's a lot of evidence that there's a lot of care there, but we're certainly not, it's not the state's theory that there's hatred. The question is, was there an unlawful purpose with regard to what he did? 33 blunt force impact sites. And if you believe Dr. Baden's testimony that she died from neck compression, it would have taken a minute to do that. That shows you malice aforethought. That shows you the unlawful purpose. There's no lawful purpose to twisting up someone's jacket while you're assaulting and beating the hell out of them. Right? There's no lawful purpose for that. So malice is clear. If you don't believe that we've proven cause of death, that's a whole separate discussion. But the malice is there. Mike Brock, possibly the worst defense scapegoat ever. Completely.
Your Honor, may we approach?
You may, briefly.
Worst defense scapegoat ever. This is a gentleman that actually has a landlady that stays at his house, that has barking dogs. He has a boss that keeps time codes. It'd have been a better call to say random homeless person than to say person that works 50 hours a week and has a timesheet that shows that. They in fact tried to make the argument that he could have been gone for up to an hour. She's like, that would be very unusual, right? His trips were 30 to 40 minutes. Supposedly the theory is that it's reasonable for you to believe that Mike Brockman, somebody that allowed this lady, he's a good Samaritan, that allows not even a friend, really an acquaintance that he'd seen a few times at the bar. He allows her to crash at his place for a weekend. Defendant, of course, wants you to believe that she's moved in with him one day after they've broken up. Right now, we've got somebody else involved in their life. Right? This is just a gentleman that is just trying to be a good Samaritan and give her a place to stay. But you can see, it sort of sounded like Sam Elliott, the what's for dinner, right? He's just super cowboy, low voice, straight shooter. That was the deal. She got to stay with me for 2 days. The 2 days was up. She had to get her stuff. She didn't show up, I left her a message, you brought her stuff back. I mean, that's pretty much exactly the way it was. I mean, pick somebody that doesn't have like almost airtight alibi during this entire period of time. If you 12 people believe that it is reasonable that Mike Brockman is responsible for this on the 13th of February, I will submit to you that you're going to have a very early day. You're going to go back, you're going to elect a foreperson, and you're going to let him, you're going to find him not guilty on all 3 counts in about 5 minutes. If you think that that is reasonable, that you have a pretty simple job for the rest of the day. Do I feel like I got a little righteous indignation? Yeah, a bit. Right? I mean, who should the police be looking at? Seen on video, picking her up at 8:30. Gives a false story about what happened. Seen on video, she's walking down a hallway perfectly fine with a black safe that they know has $1,200 in it. Coincidentally, a couple days later, he pops $1,200 cash into his bank account. Safe never shows up again, right? She ends up dead in the same clothes as when, who else of the 8 billion people on the earth should they be looking at? Obviously, we have to make sure we've eliminated everyone. But it's not a shock that that's the direction. He's given false statements. He's misdirected the police. He's been responsible for destruction of evidence. State's theory. I will admit the lack of blood on the coat is a little weird. Not going to pretend like that's not. But somebody bonked her on the head really hard, lacerating her scalp and taking a divot out of the top level of her skull. That absolutely happened. So whether it was the defendant or the mystery man, you're in the same boat. You're still stuck in the same boat. There would still be no blood on that coat. That is an issue that helps him. It does make it an interesting mystery for everyone to solve. So does the state have a theory? Certainly. If invited, state's theory is that there was some sort of assault, that her coat was twisted up, that she's down. It's pretty easy. You got somebody down, you're twisting up their coat, and you're beating the hell out of them with something. 33 times. And during that, was there an intent to compress that neck and kill? Maybe this is just an assault gone really bad. You've got an instruction that says murder in the 2nd degree does not require specific intent to kill. This isn't a murder in the 1st degree. This isn't premeditated, meant to kill case. Right? Perhaps it's just a really, really brutal assault that ended up with a tragic end to her life. But that's still murder in the 2nd degree. Bodden and Cruz. So I want to talk about them a little bit. Obviously, and I've got the 15 in parentheses, that's for my note. That's for you to pay attention to instruction 15, which is the one that talks about expert witnesses. And you're supposed to pay attention to their training, their experience, and then decide, what you believe. The reality is, on the vast, vast majority of cases, Dr. Bodden and Dr. Cruz are of one mind. Nobody's disputing how much the heart weighs or how much fatty tissue is in the liver. Nobody's having any disputes about any of this stuff. The contusions are where they are. They show what they show, right? The difference is in the interpretation of those findings. Dr. Cruz is a well-trained, professional, fantastic forensic pathologist. But she's been doing this for 5 years. And she said she'd seen 5 to 10 asphyxiation homicides in her career. Dr. Cruz's relationship with death is still developing. Dr. Bodden has had a pretty close relationship with death for over 50 years. He's completed 20,000 autopsies, including handling hundreds of asphyxiation homicide cases. You can see his resume, his CV, Exhibit 14C. Please read that. Please read the first page. The types of cases he's been called into. And this is not talking like, hey, back when I'm not even born, he's out doing things, which he was, right? This is him being brought in by Congress to do the assassination select committee to for the deaths of President Kennedy and Martin Luther King. This is him being brought in the 2000s to Poland to help them investigate the death of their president. This is him being brought in with Kobe Bryant's death here, fairly recently. This is him being brought in the very high-profile George Floyd case that America had to deal with about 3 years ago. I mean, he has been in the center. He is one of the world's most renowned forensic pathologists. And a family's quest for justice, they were not going to accept that one person could, with one opinion, say that their mom, that their sister, that their daughter got no chance to have her case heard in court. And so they went out and they found one of the world's best. And Mr. Munger is 100% correct. If Dr. Bodden would have come back with an opinion, sorry folks, but I agree with Dr. Cruz, we might all still be sitting here today, but we wouldn't have a count one. Right? We wouldn't be dealing with a murder of the second degree. Because if you've got no cause of death, that's sort of a tough case. Dr. Bodden has the experience. He has seen these cases, and she didn't just die for no apparent reason. I mean, I'm not sure if the defense is, we don't know, she just coincidentally died right after this brutal assault, just happened to die. He has given you the mechanism, and there's physical evidence to support it. We've got the abrasion on the neck that looks just like a zipper, and even Dr. Cruz says looks just like a zipper. That's why she's getting into the neck, looking at all those internal structures. But she's thinking strangulation, just like the defense wants to try that case. They're like, this isn't a very good strangulation case. I'd like to defend that case, right? So that's why they keep talking about manual strangulation. But this is not a strangulation case. Dr. Cruz said it wasn't a strangulation case. Dr. Bodden says it's not a strangulation case. Matt Wilbur, Potawatomi County Attorney, is telling you this is not a strangulation case. You know what else we have crap evidence for? A gunshot death. We also have almost no evidence of a stabbing death, right? We have none of those. Why? Because that's not this case. She died because she got brutally assaulted, and the vessels in her neck got occluded enough that it took her life. The Exhibit 100, I just want to talk about the one exhibit that the defense put in. It's the quality assurance document. Well, I mean, you should take a look at that. Because it's not like, it is literally like, was the subject adequately documented? Yes, it was. Were there enough pictures taken? Yes, there were. Was there adequate descriptions in the report? Yes, there were. The ultimate, he agrees, that is, says, was the opinion consistent with the findings? It literally, as you go through all of that, I would bet had that document been reviewed line by line with Dr. Bodden, he would have agreed with pretty much every line that was on it. She did do a fantastic job. She had accurate documentation, she had great photography, she had great technique. It's a question of, if you don't have the information in your brain that you can access, then you can't give that opinion. And if she's had 5 to 10 asphyxiation homicides in her 5-year career so far, she talked to you about all the different methods of asphyxiation, the most common being strangulation, right? So if you're thinking strangulation, then that's what she's looking for. You got strangulation, you've got smothering, you've got drowning, you've got all these things. She said there's chemical asphyxiation you get. There's all these sorts of asphyxiations. How many neck compression deaths has she handled in her career? Well, I submit to you less than 5 to 10 that are the total. As Mr. Forney said in his opening argument, right? Honestly, it's your opinion that counts. We have presented you with the evidence. You weigh it. You make the decision. This is not a place where one person or one doctor gets to say what happens with a case. We live in a system where 12 of you do. This isn't Matt Wilbur saying, do this. You get to make that decision. There are some unanswered questions in this case. Absolutely would like to have different things. Would like to have had somebody be able to examine Eileen's right eye. That would have been nice. Would have been nice to have the truck formally searched. I mean, are there mechanisms to do that? You said by consent or otherwise. The otherwise, that's what we call in our line of work a search warrant. Sure, but they require all something else. It's called a probable cause. You have to know a crime has been committed. And are they getting suspicious by later in February? You are right. They are getting suspicious. But the body isn't found until the 26th, and he is crushing the truck on the 25th. Yeah, DOT evidence, the video. They said they only kept it so long, and then it gets overwritten. Again, that's a problem. I wish we had that extra video. Why does the state not? Because somebody is playing misdirection, right? Somebody's playing the shell game, getting the police running around chasing their tail, trying to run down all of his various false statements. And so they get to look in here, and it takes days before they figure out that he's actually even gone into Omaha. Sergeant Doty, when Mr. Munger said that the statements of officers aren't evidence, that's when they're interviewing the defendant. So I just want to make that clear. That was a little bit of a tricky statement. When Sergeant Doty is testifying on the stand, and he said, we received evidence that there was $1,200 in that safe. And there's no objections, that's his testimony. What he says on the stand is evidence. When you're watching a video interview of the defendant, that's a different thing, right? Words that the defendant says are evidence, not questions and statements of law enforcement during that interview. During his interview with Sergeant Doty, this defendant said he knew that there was $600 to $700 in that safe. The other evidence that the law enforcement had received was that there were $1,200. He doesn't know how much is in there. He just knows there's at least $600 to $700. What a coincidence that the information that law enforcement received, that there was $1,200, just happened to match up exactly with the amount that he's depositing 2 days after she's gone missing. While he's not working. Hasn't shown up for work. Right? Megan Preston testified, that she never saw him again after that physically. Remember, because she watches him hanging out in the back at the parking lot at some point in a vehicle. But she sends him a message like, hey, if you're just sitting out there, why don't you come on in? Never shows up. She hadn't seen him since the 13th. She had not seen him again until she saw him in court this week. He never showed up to work. But he's flush with cash. And remember, this is before the crushing of the truck. The perfectly functional. Nobody's suggesting that you should go haggle with the recycling dude for $775 versus $750. The point is, we have a legit running F-150 with some extra aftermarket stuff that's clearly worth more than $750, and he's crushing it for $750. Why do you do that? If you're in such a position that you don't have hardly any money in your life, why are you going to purposely get rid of a truck for way less than the market value? And the reason is, and he sticks around and he watches to make sure it's crap. Why don't you just walk in? If it's such a crap truck, why don't you just walk in, say, hey, give me my $750 and walk out? But he stuck around and waited to make sure he saw that truck actually get crushed. Because the value of that truck to him at that point was its value as potential evidence. And he wanted to make sure that that went bye-bye. Cross-examination. You have instruction 41, one of the last instructions that you have. And it talks about why you should not be looking at things like Google and YouTube and all that other stuff, right? Because it says that that is stuff that comes in outside the trial process. And part of that says that they don't want you to do that, and don't do that, right? Because you can be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth, and by cross-examination. Cross-examination is the method that we use in the American justice system to test for truth. It's supposed to give you the best evidence you can. Even Dr. Bodnas, he's getting in the hot seat with Mr. Reedy, right? And he's like, I'm sure you probably don't like my aggressive cross. I expect it. That's the system, right? That's your job. You're supposed to be very aggressive with me because that's how you, the jury, get to know the truth. right? What it's not supposed to be is a gotcha tool, right? Like this. You don't even know what the standard is for reasonable degree of medical certainty in Iowa, do you, doctor? Because that's a trick question, because there is none. Because you heard Dr. Cruz. I'm certainly arguing.
Excuse me. The objection is overruled. The jury is again instructed to rely on your own recollection as to what was stated. And at this point, counsel, Mr. Wilbur, I'd ask you to move on.
I'm going to move on to what Dr. Cruz said. That he asked her, what is the standard for reasonable degree of medical certainty? And you know what her quote was? It's person dependent. It really is based on my training and experience. There is no number, right? So that's a gotcha. Yeah, that's a question that had no possible answer for him to answer correctly. He's like, I don't know what the standard is. Like, well, there's a good reason you wouldn't, doc, because there's none. It's person dependent. He told you what his standard was. He wants to be 95 to 99% sure on his opinion. Right? You never got that number out of Dr. Cruz. She just said, it's whatever I feel comfortable with. But her specific exact quote was, it is person dependent. That's what I'm talking about with gotcha cross. Right? That didn't help you as a jury try to decide actually relevant information about helping you test for the truth. The other big sort of gotcha cross is missing in this case. Right? We're hearing about this theory of like, why didn't they run down these 3 tips? Right? What happened to these other 3 people? Why did they not ask Ted Roberts that, who was in charge of the missing person? Right? They ask Ty Boldra about what happened. He's like, I don't know. I just get the tip, and it gets passed up the chain. They ask Dr. Cruz, had you heard about this? Whatever happened with this? I don't know. Right? Nobody knows. The person that knew that was actually the person running the missing persons investigation. They didn't want to ask him that question because he'd had answers for it. Right? You've heard about this. There was no DNA testing done. You don't know that. What you know is that there's no DNA tests that are in evidence in this case because nobody asked a question of Detective Brannigan what was done. Right? It was wait and then play gotcha. That's not helpful to you. This is a big case, folks. You need to be. I understand. There's a job to do. There's a client.
You may.
Okay.
The defense obviously has no burden to put any evidence on. But when they make an argument, they are subject to the same credibility determinations as anything that the state says. They don't have to put on any evidence. They don't have to ask a question. They don't have to do that for any particular witness. But when they stand up here and ask a question of why you don't have that evidence, when they have chosen to go a different route, it's for you to learn the truth in this case. Okay. Paying Emily back. Speaking of which, however, what evidence came into this case that there was some concern about paying Emily back? None. I mean, maybe there was. I mean, maybe she said, I'm bailing Grandpa out of jail and I expect I'm going to get paid back. But again, you have to deal with evidence that actually came in this case. Nobody testified. Emily never said anything about that she expected that she was getting paid back, or I was pressing Grandpa. I'm like, I really could use that $500 or $1,000 or however much it was. Right? You have no evidence of that. Dyer in the dumpster. Specifically brought up my folder on this because he said, you check your notes, and I hope you do check your notes. When Detective Dyer testified, was specifically asked, right? Said, I dropped him off. He went to the dumpster on the southeast corner of the apartment complex, looked in, and he looked in, then walked away. Not rummaged around, I suggest none of you have notes that he rummaged around, because that testimony didn't happen. Right? But he absolutely showed up on the 15th, and Dyer testified to that. This time was different. Right? That's what the suggestion for the state is why this tumultuous up and down relationship, this rocky road, this on and off again situation, this time was different. As Emily said, as Emily told us, the defendant told her, this time it's final. That's why this whole situation, why he spun up about it. Pattern of life is something that we look at when you're trying to find the when. When do we know someone is really no longer on the earth? Well, obviously when you find their dead body on the 26th, pretty good. But her pattern of life ended on the 13th. The last time anyone spoke to her, heard her voice, on the phone or in person, was on the 13th. You have no evidence that anyone on this entire planet ever heard her speak again after mid to late morning on the 13th. We have a text message that was sent. I would submit to you, while it's riding shotgun with the defendant, right? Submit to you it's more reasonable he's the one that's sending that text message. But certainly nobody heard her voice. Her daughter, you got a lot of family members here, right? Her daughter talked to her mom every day. Nothing. The CASTA agent said there were over 200 contacts early on between these two. After this date, after the 13th, 2. And again, those are texts going out. There's no conversations, 2. Because he has no need to communicate with her because he knows she's dead. So we call pattern of life, pattern of absence of life. You don't have a single bank transaction, human interaction, nothing. Because her life has ceased to exist. This is just too coincidental also to be a coincidence. I don't want to put this up on the big screen. This is Exhibit 8A. Right, this is the autopsy. And I say this is too coincidental to be a coincidence because isn't it coincidental that we have a zipper mark right next to, what's that thing right there? Oh, that looks like a zipper. Right? That's what we're dealing with right there. Right? A zipper right next to the injury on her body that sure looks like, and you'll get this, you'll get a chance to go back. You obviously have seen a lot more zoomed in ones. But this one's got the coat and the zipper right next to each other. What a coincidence. It's not like a really weird comparison to hold up that jacket, take a look at it, take a look at what's on her neck and say, looks pretty coincidental. Just sort of one of the final things about the phones, because Mr. Munger is correct. We don't have any evidence that, other than her dead body in the same clothes that she was found in when she was with him, we don't have any evidence of him traveling to that location because phones don't transmit when they're off. And we've already learned that he knows how to do that. Right? Hours at a time, those are off. This is not a location that is miles and miles away. This is Crescent, Iowa. This is just halfway between the interstate and Crescent. This is a 10-15 minute drive. Phone off, zip up, dump a body, come back, phone on, back at my apartment. It's all the time it takes. Half hour. I don't think the defense is that he did it somewhere else. But that so seemed to be the cast stuff showed that he was over in Nebraska. I just bring up again to you, take a look at instruction 19, which is territorial jurisdiction. That if a body is found, a murder victim is found in Iowa, then the death is presumed to have occurred in Iowa. That avoids the state line tap dance, right? It's a presumption. You're not required to believe that that's what happened, but that is what we call a legal presumption. So the fact that she was found here, that's enough. Again, this is not a strangulation case. Dr. Cruz was looking for that, and she did a good job looking for it, and she did a good job of eliminating that. Dr. Bodden does not disagree. This is not a strangulation case. I'm getting very close to being done here. I want to sort of give an apology of sorts. I apologize for the tech problems that we had on day one. It's a struggle when you've got county computers and state court systems, and you're trying to get them all to talk to each other. You can't really control what a witness says on the stand, but you ought to be able to control your computer. And I apologize for that, because I don't like to see that happen. I apologize because I'm sure a lot of this is really boring. I mean, honestly, right? When you expect, closing arguments are, can be exciting, and listening, I think, to to witnesses like Dr. Cruz and Dr. Bodden that are obviously, very articulate and do a good job explaining complex information. But this is not like TV. You got to sit through days of pretty drudgery work, and I apologize that you had to do that. Sorry, lose my voice. I don't apologize for putting in the evidence that we did, because we're going to give you the good, the bad, and the ugly. That's our job. We didn't make a choice. This is a case where the defendant took three things. He took her life, he took her property, and then by dumping her in a ditch with some trash, he took her dignity. This is the time for justice. Mr. Bringer is presumed innocent and not guilty until the evidence establishes guilt beyond a reasonable doubt. This trial is over. The evidence is in. I would submit to you that we have overcome his presumption of innocence. Eileen was a mom. She's a grandma. Daughter. Sister. And she tragically lost her life. I'm asking you for a verdict of form of verdict number 1. Hold him accountable. Form of verdict number 9. Hold him accountable. Form of verdict